In the previous view segment, I focused some on the Marshall and Tawney eras of the court, and these spanned roughly from 1801 to the Civil War. In this one, I'd like to make a few general points, first about the Supreme Court, and then I'd like to highlight a few of the court developments between the Civil War and the era of the 1930s, which is covered in the latter portion of the reading assignment for this week. Now, in terms of some general points, keep in mind that the court does not operate in a vacuum. It's very heavily influenced by the historical circumstances, the culture, the politics of any given time. And this is really as it should be. The founders fully expected the court to be a part of our three-part political system. And most of the founders never really imagined that the court would somehow be beyond politics, as some Americans today seem to think it should be. Second, most of the court decisions over time have involved defining what state governments and the federal government in Washington can and cannot do. We're very fortunate, I think, as a society to have somebody that can help mediate among the players in our multi-level system of government with roles and duties that are kind of spread across local and state and the federal government. Third, it's also true that over time the court has gradually allowed the federal government increased authority over the state governments. And this has been especially true after the Civil War, and the move has just accelerated over the last century, especially given the various wars that we've been involved with. First, the wars in Europe, and here I'm talking about World War I and II. The wars in Asia, that would be Korea and Vietnam. The Cold War, and then, of course, more recently, the first Gulf War, and then the wars in Afghanistan and Iraq. There's really nothing like wartime conditions to strengthen the hand of a central government, and this is true no matter what kind of government one has. Fourth, the court usually does respond to public opinion, but often lags far behind public opinion for a variety of legitimate reasons. I mean, keep in mind that the founders were trying to develop a governmental form that would be resistant to change, and the Supreme Court really enabled them to slow down the change process. And finally, the court can in fact shift directions quickly. Sometimes the court will hold several related positions for decades and then change those abruptly after just one or two appointees come on board. Now, getting back to the historical narrative, during and after the Civil War, the court addressed a number of war-related issues, especially civil liberties cases, as opposed to claims against the government per se. In the latter two to three decades of the 19th century, the court took up a range of cases that arose from industrialization and the expansion of commerce. Now, both of these trends really dominated that particular era. So be sure to pay special attention to Rehnquist's material on, for example, the railroad industry and how transportation expansion really transformed the nation. So by the arrival of the 20th century, the nation was growing quite rapidly and proliferating a number of corporations. And as these corporations grew, they began to swamp small businesses as the dominant form of commercial organization. And this led in the first couple of decades of the 20th century, the court took up a number of cases wherein the justices began allowing states to regulate the workplace. And this period saw the establishment of our legal regime that limits the work week to about 40 hours and that has placed restrictions on how firms can employ children and women, for example. Now, one of the things that's missing in Rehnquist's otherwise decent story was the web of the so-called Jim Crow laws that sprung up, especially in the South, in the wake of the 1896 Plessy ruling that condoned separate but equal treatment of blacks and other minority group members. What this did was it gave rise to a really heavily segregated social system in the South. But keep in mind that the North was also segregated in many ways as well, although what happened in the North was really more through long-standing discriminatory practices rather than rules and regulations as in the South. And this system of discrimination and segregation was targeted by the civil rights movement beginning in the 1940s, but it wasn't officially overturned by the court until the 1954 Brown versus Board of Education decision. And even then, it took several decades more, plus lots of federal involvement, to continue making progress on the desegregation front. Now, the latter part of the reading for this week involves Franklin Roosevelt's attempt to pack the court with his own appointees and what happened as a result of that policy move. Now, this was a case where the president really went to war with the Supreme Court and lost. This showed that even a very popular president could get into political trouble by taking on the Supreme Court, which by this point was pretty well established in the nation's political history. And it was accepted by most voters as really a co-equal part of the tripartite government system we have in place. Now, what happened in a nutshell was that FDR was elected to office in 1932, promising to take aggressive action to create jobs in the wake of the Great Depression. And he had a heavily Democratic Congress behind him, and several of the initial programs that were passed under FDR in those first few years of his administration were deemed by the court to give the federal government too much authority to act in areas that it had never acted in before. So FDR responded after his 1936 re-election by sending to Congress a plan to expand up to 15 the number of justices on the court. And had this passed, it would have enabled him to appoint quite a number of new members almost immediately, and this could have given him a working majority of justices on the court. But the plan failed in the Senate, and Rehnquist discusses how that happened. And the whole plan eventually died a rather ignominious death for an otherwise popular and powerful president. Now, of course, within a relatively short period of time, a number of the sitting justices began to retire, which meant that FDR got a chance to appoint his own people to the court. So if FDR had really just been patient a few more years, he would have been able to enter history without this embarrassing attempt at executive branch overreach on his record. But patience has always been a virtue that some occupants of the White House have lacked. And I would add that by the time he finally died in the spring of 1945, after having been elected to 4 terms in office and having just recently begun his 4th term, FDR had by that point actually appointed nearly the entire sitting Supreme Court at that time. So he did end up packing the court, although not doing so by the means that he originally proposed.